Turnbull government MP Nola Marino may have acquired Italian citizenship through marriage, in what would represent a new twist in the eligibility crisis that has engulfed the federal parliament. Ms. Marino's case also highlights a gap in the proposed new disclosure regime being debated by Prime Minister Malcolm Turnbull and opposition leader Bill Shorten, which does not consider the possibility of dual citizenship attained through marriage. The development comes after fellow Liberal MP John Alexander declared he was still waiting on conclusive advice from the UK Home Office about his citizenship status. There is mounting speculation he will resign by Monday, sparking a by-election in his Sydney seat of Belog. Also on Friday, the High Court decided to examine the eligibility of Holly Hughes, the Liberal who was set to replace former Deputy Nationals leader Fiona Nash. Ms. Hughes is under a cloud because after last year's election she took up a government job, which could disqualify her from office. The citizenship spotlight has now fallen on Ms. Marino, who married her husband, Carmelo Marino, in Western Australia in 1972. Mr. Marino, who goes by the name Charlie, was born in Italy in 1950 and emigrated to Australia with his parents the following year, according to ancestry documents seen by Fairfax Media. That means Mr. Marino was an Italian citizen at birth. If Mr. Marino naturalized as an Australian before 1972, he would have lost his Italian citizenship and not passed it on to Ms. Marino. But if he retained it, she too would have become an Italian citizen. Official Italian government advice clearly states, foreign women who married an Italian citizen prior to the 27th of April, 1983 automatically acquired Italian citizenship on the date of marriage. Ms. Marino, who as the chief government whip in the House of Representatives is responsible for party discipline, has so far failed to clarify the facts around her situation, refusing to say whether she or her husband ever relinquished Italian citizenship. While people who marry Italians now must go through a long naturalization process to become citizens, the official Italian government advice emphasizes that for people in Ms. Marino's situation there is no need to naturalize or activate. There is a recognition process for people in Ms. Marino's situation. This is not considered a prerequisite to citizenship. Italian immigration and citizenship expert Sarah Bucalorsi, who works with leading consultancy Mazeschi, confirmed that unless Mr. Marino relinquished his citizenship, he would have passed it on to Ms. Marino. This means that Nola could request the recognition of her Italian citizenship, Ms. Bucalorsi said. Ms. Marino and her office declined to answer a detailed series of questions put by Fairfax Media, but in a statement said, "I am an Australian citizen and only an Australian citizen." The High Court made clear that Italian law requires the taking of the positive steps to acquire citizenship. "I have never taken such steps," she said. In considering the case of Turnbull Government Cabinet Minister Matt Carver last month, the High Court found it could not be satisfied he was a citizen of Italy, in part because he took no positive steps to attain the status. But Senator Carver's case related specifically to Italy's notoriously complex system of indefinite jus sanguis citizenship by descent.